This is Barry Zalma speaking for Claim School Incorporated's Zalma on Insurance, a blog. Today I'd like to speak about why rescission will not defeat a negligence claim by the insured against his insurance agent or broker, and why the courts will conclude that an agent can be sued for creating a false application that results in rescission. And that's because rescission is an action on a contract, while a suit against the agent for negligence is a tort action and has no relationship to a contract. Therefore, the Michigan Court of Appeals reminded that in a prior action it had held that defendant Farm Bureau General Insurance Company of Michigan was entitled to rescind plaintiff's insurance policy for material misrepresentations made in the application. The court reasoned that regardless whether the plaintiff or his insurance agent contributed the false information, the plaintiff affirmed any misrepresentation by signing the application. However, in Lawrence S. Holman v. Farm Bureau Insurance Company of Michigan and Jonathan Heinzman Agency, a August 4, 2022 decision of the Michigan Court of Appeals, after losing his case because of the rescission, the plaintiff then sued his insurance agent, claiming he was negligent in filling out the application. Plaintiff had purchased a 2007 Mercury Mountaineer from a car dealership and called Farm Bureau sales agent Jonathan Heinzman to obtain insurance on the Mercury. Heinzman testified that he filled out the insurance application on the basis of answers he received from plaintiff over the phone. The completed application misrepresented material facts about the fact that Holman had not driven or moved any vehicle owned by him, which was not insured for the preceding 6 months. An AAA, or Automobile Association, policy was then listed as the plaintiff's current insurance, with an expiration date before the effective date of the new policy. Heinzman faxed plaintiff a temporary certificate of insurance and asked the plaintiff to send proof of his prior insurance. That evening, plaintiff faxed Heinzman a AAA certificate of insurance that expired 2 years before his application to Farm Bureau. Plaintiff's application was sent to Farm Bureau without proof of prior insurance, and on January 30, 2015, Farm Bureau sent plaintiff a letter explaining his application could not be accepted because it was incomplete. Plaintiff brought suit against Farm Bureau to recover PIP benefits arising from the accident that put him in a coma for a month, and the trial court granted summary disposition to Farm Bureau in Holman versus Basha, being Holman 1, issued November 29, 2018. Because a panel of the Court of Appeal affirmed the trial court's ruling that a notice of cancellation was not required for the temporary certificate of insurance because it expired by its own terms on January 29, 2015, and therefore plaintiff did not have coverage on the date of the crash. The Court of Appeal also held, however, that Farm Bureau was entitled to rescind the policy for misrepresentations made in the insurance application. The record evidence demonstrated that these representations were false and material, and that was the basis for the rescission. Plaintiff signed the application after having had the opportunity to read and review it. Because plaintiff signed the application after, quote, he skimmed over it, close quote, he affirmed any representations or misrepresentations in the document. Heinzman testified that he knew that Farm Bureau would cancel the plaintiff's policy. According to his notes of his communications with the plaintiff, however, Heinzman told plaintiff that Farm Bureau would probably cancel the policy. Similarly, after receiving an email from Farm Bureau regarding the missing proof of prior insurance, Heinzman called Plaintiff and told him that Farm Bureau may terminate coverage. Heinzman also testified he offered to look for coverage for Plaintiff through a different insurance company. In contrast, Plaintiff denied that Heinzman told him that Farm Bureau would not be insuring him or that he needed to look for other coverage. Heinzman moved for summary disposition of the suit, arguing that the plaintiff's claims were barred by the doctrines of res judicata and collateral estoppel. The trial court granted Heinzman's motion for summary disposition. The court determined on the basis of collateral estoppel that Holman 1 was dispositive of the causation element of plaintiff's negligence action. The court's reasoning, however, was that plaintiff, who had argued that the trial court erred by concluding that his negligence action against Heinzman was barred by the doctrine of collateral estoppel, it agreed. The doctrine of collateral estoppel precludes relitigation of an issue in a subsequent different cause of action because the same parties, when the prior proceeding culminated in a final judgment and the issue was actually and necessarily determined in the prior proceeding. Generally, for collateral estoppel to apply, 3 elements must be established. 1, a question of fact essential to the judgment must have been actually litigated and determined by a valid and final judgment. 2, the same parties must have had a full and fair opportunity to litigate the issue. And 3, there must be a mutuality of estoppel. To establish a prima facie case of negligence, however, a plaintiff must prove the defendant owed the plaintiff a legal duty, the defendant breached the legal duty, and the plaintiff suffered damages, and the defendant's breach was the proximate cause of the plaintiff's damages. The trial court concluded that Holman 1 held that plaintiff made the misrepresentations in the application, and that as a result plaintiff could not establish that any negligent conduct by Heinzman caused plaintiff's damages. As noted in Holman 1, the panel determined that it was meaningless whether Heinzman provided the bogus AAA policy number in the application, because plaintiff as the contracting party had a duty to read the contract and know that he signed it. In other words, the panel did not need to decide whether any misrepresentation was attributable to plaintiff or to Heinzman for purposes of determining whether Farm Bureau was entitled to rescission, because plaintiff affirmed the contents of the application as the signing party. The court found in favor of the insurer, relying on the principles of contract law that failure to read an agreement is not a valid defense to enforcement of a contract, and contracting parties have a duty to examine a contract and know what the party has signed, and the other contracting party cannot be made to suffer for neglect of that duty. Stated differently, under contract law, a signing party is bound by the contract's terms, regardless of whether they've read them. Accordingly, it was immaterial who contributed the false information to an insurance application for purposes of determining whether an insurer may rescind the policy. The contract principles relied on in Holman 1 have no application in a negligence action concerning whether the insurance agent breached a duty to the insured. Because plaintiff's negligence claims in the instant case are tort-based, the Court of Appeal concluded that the plain language of the comparative fault statutes required the trial court to give defendants requested instruction regarding comparative negligence. The Court of Appeal additionally concluded that plaintiff's admitted failure to read the policy could qualify as comparative negligence, and that the trial court should have permitted a jury to consider whether plaintiffs unreasonably failed to read the insurance policy and related documents. The insured's failure to read the insurance application and related documents was relevant to comparative negligence, and the jury could reasonably determine it was the proximate cause of the insured's damages. Applied here, an insured's failure to identify a misrepresentation in the application allegedly made by the insurance agent should not preclude a negligence action, but it may be considered by a jury when determining comparative fault and proximate cause. Given that captive agents are order takers, it follows that there is a duty to do so accurately and not contribute false information to the application, whether purposely or mistakenly. It was not necessary for the Court of Appeal to determine there was a special relationship between Plaintiff and Heinzman, because that case falls within the more general limited duty to take orders. The court's prior decision granting rescission to the insurer does not preclude a negligence action against the insurance agent. The trial court's decision was reversed and remanded for further proceedings. In my opinion, there's no reasonable basis for an insured or an insurance agent seeking to obtain insurance for a prospective insured to lie to the insurer to obtain the insurance. There is no question that the policy was acquired as a result of a material misrepresentation sufficient to require the rescission of the policy. Since the plaintiff claims he told the truth to the agent, then there may be a case for the agent's wrongdoing. If he lied to the agent, he will lose the negligence case. If both lied, the jury will determine what percentage of responsibility each obtains. A trial should go forward and a decision will be made. This video was adapted from my blog, Zalma on Insurance, which is available at www.zalma.com/blog, to which you can subscribe so that you can receive these daily blog postings. Thank you for your attention.